Good evening and welcome again to the Defense Chronicles. This is Leslie Bocobo. Tonight we have with us Atty. Dennis Manalo. Good evening, Atty. Manalo.
Good evening, Leslie.
Immediately, Atty. Manalo, take us to witness Harvey K. During the testimony, we witnessed the statement of Senate President Juan Enrile, scolding him, telling him and asking him the question, are you influencing this court? By doing what he did, he went to the office of the Senate President and submitted those documents. What are your views on this?
Well, I think the Senator Enrile picked up from the purpose of the testimony, the purpose of my presentation of Harvey K.
Yes.
I was very clear that he is presented to prove that he was unduly swaying or influencing the decision of the court in this case. And even before I terminated my examination, I would sincerely believe in all humility that the Senate President was already convinced that Harvey K was that the act of Harvey K indeed was an undue influence on the senator.
Yes. Now, it turned out that he in fact alerted some members of the press to accompany him as he was to deliver those documents to the office of the Senate President. This is very clear. In fact, you brought it out from him, right? That
yes, he was denying it at first, but eventually
the truth came out.
The truth came out that he actually communicated with people from the press, and Senator Enrile was felt that this is something that was disrespectful.
Yes. Now, we were in the internet world, Atty. Manalo. Some members and friends of ours were still trying to get copies of the postings and the comments that he had made, and apparently most of them were taken down. What does this say? Is it an admission?
Well, definitely there is clearly some sort of fear that what they may have done might be interpreted as a transgression of law. We have taken the position that this case has been too much publicized, and the negative reports or comments about the Chief Justice, baseless and unauthenticated, have no use in the impartial and objective decision-making needed for this particular case. It will only confuse the issues, and if eventually our purpose here is to be able to render a just and fair verdict, then acts like this should not be tolerated, not just in this case, but in any case for that matter.
And why do you think those documents were unsigned?
I think those documents were unsigned because they were fabricated. It's as simple as that. Nobody was willing to sign.
Nobody wanted to take ownership of it.
Of course. Definitely a fabrication.
That in itself is already proof that this could be a fabrication, in fact, of something.
Yes. This is definitely a proof that there are people out there who want to get a conviction of the Chief Justice to the extent that they are willing to come up with lies.
Yeah.
And are we a society that wants to go that way? Are we willing to take that path where the ends will justify the means?
Yeah.
Because that sets a very dangerous precedent, and I'm referring to PRECEDENT.
Yes.
Yeah.
Precedent.
Yes, precedent.
Yeah.
Because if we go that way, then we are going to expose ourselves to bigger and more volatile problems.
You mentioned the word lies. Are we made to believe now, attorney, that the 82 bank accounts are now similar to the 45 properties? They are simply put bloated. They're fabrication. It's huge numbers that they were trickled down to about just 5 properties.
Yeah. You have to understand that what was presented by the Ombudsman from the AMLA were not authenticated.
Yes.
The Ombudsman was very clear that she just received the documents and she did not take any further action on them. She did not verify them, she did not examine those who prepared, so she was relying solely on what was written on these documents. Under the law, it would be unauthenticated, it would be unreliable.
Yes.
And to us, it could be subject to misinterpretation. Definitely, transactional balances would only indicate the flow of money. If, let us say, you put 1 peso in the bank today, and in the afternoon you withdraw it.
Yes.
And then the following day you deposit it again.
Yes.
And then withdraw it in the afternoon and do it for 10 days consecutive. Does that mean you have 10 pesos? It only means that you still have 1 peso, except that you were just transferring it from one account to the other.
Now, why would that be done? I mean, a lot of people now are saying the Chief Justice is into dollar trading, which explains a lot of movements of his money. What can you say about this?
Well, in the first place, let me be clear about it. We're not even sure whether these are his money. What we know is that there were accounts reported claiming that these funds belong to him. But in any case, the movement of the money would not be suspicious, especially if these funds are put in time deposit accounts, which have maturity dates. You have to understand that when a time deposit expires, the bank will have to ask you whether you will renew the account or not. And if you say that you will renew, it will be opened in a new account. It doesn't mean that you have another set of funds coming in. It's just the same fund. So,
now, let's go to yesterday, Tony Manalo. We had the Ombudsman at the witness stand, and again, a lot of people are saying that she, in fact, left a chilling effect on the other members of the court, in the sense that in her lies alone the sole authority to investigate anyone in public office. If the person being investigated is a political foe, then sure enough, he can be.
What is fearful about the exercise of authority of the Ombudsman, which she exhibited yesterday, is not her investigatory powers. It is the unbridled usurpation, or may I say violation of constitutional restrictions, particularly against unlawful searches and seizures. That is actually what causes a chilling effect. Remember, under the Constitution, the right to privacy of an individual is respected, and therefore there can be no search done by the government unless it is by court order after establishing probable cause. But in this particular case, there was no such court order, and therefore there was no such determination of probable cause, and therefore it means that the right to privacy can be transgressed, and the protections provided for by the Constitution may be set aside by the Ombudsman. I don't know if that is something that will withstand the scrutiny of the Supreme Court. Definitely for me, I have, in my many years of practice as a lawyer and in my years as a law student, I would think that this will not stand the test of the Bill of Rights, specifically the right against unlawful searches and seizures.
We're back with the Defense Chronicles. Attorney Manalo, a lot of people again are saying there must be an act of conspiracy here between the powers that be in government now with the ombudsman in the way they are now pushing the Chief Justice against the wall. What can you say about this?
The questioning of Senator Cayetano today, which was addressed to me,
Yes.
is that your theory of conspiracy alone will not result in the acquittal of the Chief Justice. And he is correct. But by way of putting it in its proper context, the conspiracy theory was only presented to establish the motive behind the impeachment complaint.
Yes.
The truth is there is no sincere desire on the part of those prosecuting the Chief Justice to enforce our laws.
Yes.
And in fact, the only desire is to remove him from office because of political partisanship.
Yes.
And to us, that weakens. That is a very strong theory that we can espouse, because it weakens the credibility of the evidence presented by the prosecution, if that is proven to be true.
Now, Atty. Manalo, let's go to one of the former senators of the Republic, Senator Francisco Kit Tatay. Earlier, I interviewed him concerning his column today entitled Recusing Angara. My question is, the defense did not ask the Senate to recuse Angara. Instead, you asked Angara to recuse himself. Isn't that a bit asking too much of a senator judge? What can you say about that?
We were actually taking off from the statements made by Senate President Enrile.
Yes.
That insofar as recusation or inhibition is concerned, they should be addressed to personally to the senator judge involved, because he is the only one who can decide whether he or she will inhibit or recuse himself from the case. So that's why we addressed it to him personally. We did not intend in any way to disrespect Senator Angara. We were just pointing out circumstances where we feel may be a basis for his recusation under the rule on voluntary recusation provided for in the rules of court. We took that chance because we felt that there were matters that have been publicized which we feel may be interpreted as that may be seen to compromise whatever action he may take with regard to the impeachment case.
Now, on that note, and in the column of former Senator Tatay, he mentioned that members of the defense are sort of asking Senator Judge Angara now to vote for an acquittal in exchange for this. Is there any truth to that matter?
My understanding is there was that portion, an innuendo.
Yes.
But to me, that is just part of the literary style of presenting the arguments contained in the motion.
Yes.
Of course, we were not. We would never take a position insisting on that a judge take a particular course of action, because, at the end of the day, this is a matter that is within the discretion of the senator judge, and nobody can interfere with that discretion.
The Senate Impeachment Court recently adjourned to resume on Tuesday, May 22, and we were told that Chief Justice, no less than the Chief Justice, will appear as witness. What are your thoughts on this? Did you expect this already, Atty. Manalo?
Yes, of course, we were already expecting this. And, well, to me, this already comes down to the Chief opening up to the senators and exposing himself for who he truly is.
Yeah.
And this now boils down to a matter of credibility. Who is more credible? Is it the prosecution who has presented 45 properties when in fact there are 5? Is it the prosecution who has presented documents before the court involving bank accounts which under the law are absolutely confidential? Who has presented to the court documents the sources of which are questionable, unidentified? So, and a lot more things that has happened during their term. The chief right now will be in a position to save himself.
Yes.
I honestly believe that most, if not all, of the senator judges are in that position right now. We want to hear the Chief Justice. And if he comes across to us as somebody who is credible, who is believable, then they will be ready to acquit.
Now, you mentioned, and I quote you, the chief will be in a position to save himself. I'm under the impression that and I read an article that he is sinking, when in fact he is a man who remains afloat. And Attorney Manalo, you will agree with me that I am convinced that he is ready to face his accusers.
Yes.
Because he is in high spirits, even as we speak right now.
Yes, that is also my understanding right now of the situation. This man has not been beaten up. In fact, he has been strengthened and energized by what has happened before the impeachment court. Now he is truly of the belief that all the accusations against him are a lantern of lies. That were his very words. So expect the truth to come out on Tuesday.
So thank you very much again, Attorney Manalo, for your time. Till next time.
All right. Thanks. You're welcome, Leslie.
This has been Leslie Bocobo for the Defense Chronicles. Thank you for joining us once again.